Third reading of House Bill 622, Senate Draft 1, relating to evidence.
Discussion. Senator Sloan.
Thank you, Madam President. I rise to support this bill with reservations.
Please proceed.
This is the so-called Journalism Shield measure. It's one of the few things that Hawaii has done right over the years. We passed a law 5 years ago. It was hailed across the country as a model for legislation to protect legitimate sources of those in journalism, and particularly those in the new media and electronic media. We had a thorough study of the bill by the judiciary. We had 5 years, as I said, to look at this measure. And the reason the bill came up again this year is because it had a sunset date. It's supposed to sunset the end of June of this year. The simple thing to do would be to recognize that, in fact, this is a good bill that has worked, that has the support of everyone in the Fourth Estate, the journalism community. They've all come together to support it. All they wanted to do was to remove the sunset date and continue the law. But in fact, this version, the Senate version, is so convoluted that there have been some harsh words written about it by people in the industry who have all said that basically it would be better not to have a law than to have this version of the law. I'm supporting with reservations this bill in the hopes that it will go to conference and in the hopes that reason will prevail, and as I say, we'll have one of the better pieces of legislation that's come out of this state legislature. Thank you.
Further discussions. Senator Thielen.
Thank you. Thank you, Madam Chair. I'd like a new microphone.
It's on.
All right. Thank you, Madam Chair. I rise in opposition to this bill.
Please proceed.
I understand the frustrations with so many people engaging in social media today about having responsible statements, but I'm not comfortable with the way this bill defines journalists. We're in the midst of a real change in our journalism industry and our publishing industry. We've seen newspapers collapse around the nation, magazines, even books are going down. And we're looking for a new model across our nation, and I don't think it's appropriate at this time to define a journalist as somebody who has a subscription, because the internet is deemed as free. And so we have a lot of old-time reporters who are casting about trying to find ways to be able to report their stories and reach people, but looking at revenue sources such as advertising and the like. And so I'm very uncomfortable with this definition of the bill. I hope we can come to some better accommodation in conference committee, but I need to vote no on this measure. Thank you.
Further discussion, members? If not, do we have unanimous? Senator Key.
Thank you, Madam President. I rise in support.
Please proceed.
Thank you. Just want to make a couple comments and thank the Judiciary Committee, and particularly the staff of the Judiciary Committee, for working hard on this issue. I think it's important to note that over the last 5 years, there has been only one case where the shield was used. And in that one case, it happened to be a documentarian who asserted his rights not to divulge his source on the presumption that his documentary was accurate. Because of the shield, no effort was made to identify the source, and the presumption that his documentary is accurate is just that, a presumption. There has been a lot of self-serving comments recently in various iterations of so-called journalists. Regardless of the iterations, the history is clear. And so let me read and enter into the record the opinion of the Supreme Court of the United States, who said, quote, "The prevailing view is that the press is not free to publish with impunity everything and anything it desires to publish. Although it may deter or regulate what is said or published, the press may not circulate knowing and reckless falsehoods, damaging to private reputations, without subjecting itself to liability for damages, including punitive damages or even criminal prosecutions. The Supreme Court of the United States also said that it decided in Brandsburg that there is no First Amendment privilege protecting journalists from appearing before a grand jury or from testifying before a grand jury or otherwise providing evidence to a grand jury regardless of any confidence promised by the reporter to any source. The highest court has spoken and never revisited the question. Without doubt, this is the end of the matter, end quote. Many things were said at the public hearing. I would like to point out the representation made by Jeff Portnoy in that the Judiciary Committee on the Rules of Evidence had unanimously agreed is in fact incorrect. Because the Deputy Attorney General, Deidre Marie Iha, informed the committee that in fact what Mr. Portnoy said was untrue. And when asked by one of the members of the committee, how did she know? She responded, because I was a member of that committee and I voted no. Many things have been said. The fact of the matter is, this bill represents the recommendations of the Attorney General. This bill represents the recommendations of the Judiciary Committee on the Rules of Evidence. This bill represents the assistance and help of the American Civil Liberties Union. This bill tightens up definitions. It does not continue with reckless regard to undefine the territories of what is and what is not privileged information. This bill relies on the judgment, not once, not twice, but 3 times of the United States Supreme Court. And this isn't the end of the road. Presently, in Denver, a reporter is trying her best to prevent the identity of 2 law enforcement officers who tipped a Fox News reporter of information that allegedly the gunman on the theater shooting had in a notebook that was then disclosed. We will find out very shortly that this information, whether or not it needs to be disclosed, shall be disclosed. But clearly, the reckless abandon of so-called journalists is limited by this effort by the Judiciary and Labor Committee. Thank you.
Further discussion, members? If not, do we have unanimous consent?
Can you note my reservations?
Reservations for Senator Ihara? Senator Thielen? No vote for Senator Thielen. Senator Sloan?
Thank you, Madam President. Just a brief rebuttal.
Short recess.
Short recess, subject to the call of the chair. Senate, please come back to order. Senator Sloan.
Thank you, Madam President. Just a brief rebuttal, as I mentioned. First of all, the fact that there was only one case involving this law in 5 years actually should be interpreted that the law works and that there have been no excesses. In terms of reckless disregard or reckless abandon, certainly, even on free speech, there are limitations. That's always been recognized. It still is recognized. Does not, however, impact our Hawaii law. Thirdly, the citing of the U.S. Supreme Court case, the Brandsburg case, has been pointed out that, in fact, that case is not on point, does not affect whatsoever the real details of this particular Hawaii law, and there is a differentiation that gives no shield or no protection to any journalist in criminal matters. So I would urge my colleagues to support the measure in conference to make sure that, in fact, we have a good bill and a bill that is not one that seeks to throttle and silence free speech and a free journalism industry in Hawaii. Thank you.
Further discussion, members? If not, do we have unanimous consent? No votes for Senator Thielen, all others in the affirmative.
24 ayes, 1 no.
House Bill 622, Senate Draft 1, passes third reading.
On page